Okay, let's talk about alternative dispute solution in on criminal act in Indonesia. My name is Nurzaman Yunanda, and let's talk about this. Law time. Law in Indonesia. The implementation of enforcement of law in people's lives have a very important meaning in creating justice, certainty, and benefit for the whole community. Laws that are run by provision and are followed by every society can create justice. The law must be implemented and obeyed by every individual by Article 27, Paragraph 1 of the Constitution, which affirm that all citizens are equal before the law. The meaning of equality before the law is found in almost all state constitutions. This is norm that protect the human right of citizen. If the law is obeyed by every individual, then the law can provide a sense of justice, certainty, and good benefit for the community. There are two types of law in Indonesia, and the first one is public law. Public law is a law that regulate the relationship between citizens in a certain country, just like Indonesian and Indonesian people. This public law is more like everything you do will does it have anything against the law in the country or not? It's related to the state, and equipment regulate the state, just like traffic law and murder law and anything else. Public law focus on the issue of benefit or benefit. The scope of public laws is constitutional law, state administrative law, criminal law, and international law. Public law is maintained by the state and government, which is active. And there's the second type, that is a private law. Private law regulates the relationship between one individual and the other, where this focus on individual interests. Just like, when you have something and then somebody tries to take it from you, it also, can count as a private law. Just like, heritage, land stuff, and buying and selling law. This is private law. Private laws tend to focus on personal or individual relationship problem. Private law is in civil law and commercial law. Private law is maintained by individual and a positive government, because these two person or these two individual person will dispute themselves, and the government only taking the last judgment, I guess. Correlation between both of the law. I'm sorry, there's some typo there. Criminal and civil law in some cases in business relationship can occur together. Related ongoing business relationship can be explained as private relationship. But on the other hand, if studied more deeply, business relationship also have links with public law, issues which are included in the category of criminal law. One example is when case of violence occur, the crime of violence is included in the category of criminal law. In other cases, the relationship between one party and another is in violence and is included in the category of civil law. There's 5 main factors that form the basis for the needed for the development of alternative dispute resolution in Indonesia, and one of it is as an effort to increase competitive in living investment to Indonesia. Legal certainty, including the availability of efficient and reliable dispute resolution system, is an important factor for economic actors to invest in Indonesia. Alternative dispute resolution based on the principle of professional independence dispel potential investors' doubt about the existence and reliable dispute resolution from able to guarantee a sense of justice. The second is community demands efficient dispute resolution mechanism that can fulfill a sense of justice. Not lose or win solution, but win-win solution. Effort to balance the increasing critical power that community coupled with demand for active participation in the development process, including decision making and public affairs. The right of the community to participate in the stipulation of the public policy has resulted in the need for forum of or dispute resolution mechanism to accommodate conflicting opinion that arise from the participation of the community. And the fourth is to foster a climate of fair competition or peer pressure for the judiciary. The presence of alternative dispute resolution in institution and quasi-court or tribunals, if they are optional, there will be selection process that describe the level of public trust in certain dispute resolution institution. The presence of comparison of peers in the form of alternative dispute resolution institution is expected to encourage this dispute resolution institution to improve public image and trust. The fifth is as an anticipatory step to stem the rush of a case flowing the court. Well, there's this mediation as alternative dispute solution. Penal mediation that is mainly used in underage law is actually a good example that we can use in Indonesia. Penal mediation is a law enforcement step that applies the value of restorative justice. Even now, this justice is said to be a progressive approach as stated by Mark Levin. The approach that used to be declared obsolete, ancient and traditional is said to be progressive approach. According to Bardan Nawawi Arif, the reason for using penal mediation in the settlement of criminal cases is because the idea of the penal mediation is related to the issue of criminal law reform or penal reform. It is also related to pragmatism. Another reason is the idea of victim protection, the idea of harmonization, and the idea of restorative justice. The idea of overcoming the rigidity or formality and negative impact of the criminal justice system and the prevailing criminal system, as well as effort to seek alternative form of punishment other than imprisonment. I'm sorry. The Indonesian people is resolving the case both civil and criminal with penal mediation is not a new thing. This is evidenced by the settlement with deliberation approach. Historically, the culture of Indonesia, people highly uphold consensus approach, which prioritize in the traditional decision making and settlement through the customary mechanism. Some conduct research on penal mediation in environmental crimes or penal mediation and medical malpractice criminal case. There are 7 categories that can be used in mediation as alternative dispute resolution, because not every criminal act can be resolved with this mediation. The first of it, the violation of criminal law, is included as the category of complaint offense, or just a little bit offense, both absolute complaint and relative complaint. The second, violation of the criminal law has a fine, and criminal threat of the violator has paid with fine Article 80 of the Criminal Code. The third is violation of the criminal law is included in the category of violation, not crime, which is only punishable by fine. Violation of the criminal law included criminal acts in the field of the administrative law, which place criminal sanction of the ultimate remedium. The violation of criminal law is categorized as light, mild, and law enforcement officials use their authority to exercise discretion. Violation of ordinary criminal law, which is terminated or not possessed by the Attorney General or the penner, by the Attorney General by the legal authority he has. The violation of the criminal law is included in the category of violation of the customary criminal law, which is resolved through customary institution. The conclusion is, from the explanations above, the conclusion can be drawn. Namely, mediation can be used in resolving criminal cases. However, not all criminal cases can be resolved through mediation. There are a category of the crimes that can be resolved by mediation. The application of mediation in criminal cases is a liberation of restorative justice, value that are oriented towards resolving cases that benefit parties, victim, perpetrator, and the third parties, namely society. Indonesian people are used to the way of deliberation and consist. With mediation for the settlement of criminal cases, many legal aspects are used and led to a better trial. I think that's it for me, and thank you for listening. Goodbye. And